Good day, everyone. Welcome to my presentation. My name is Michelle Sanda, and I'm a GZHU student at Herbert Chapel Law School. My facilitator is Mr. Ngosana Maposa, and this module is called Jurisprudence. And in this module, I'll be presenting on law and society. So the writer on this presentation is going to firstly define the key terms, that is law and society. We can't go anywhere without depicting what law means. We can't go anywhere in this presentation without depicting what society means. So the writer will also do this, or also achieve this in relation to in the context of the works of the leading sociologists, in particular Rescue Pound, Max Weber, Emil Durkheim, and Karl Marx. So I'll first define the term society. Society can be defined as an association or a company of persons, generally not incorporated, united together for any mutual or common purpose. In a wider sense, the community or the public, the people in general. That's the term community. Another author described society as two human beings who can be described as weakened animals who can be easily swayed by the slightest sniff of materialistic gains like power, finances, luxuries, leading to unwanted acts causing the creation of restrictions. Then the term law. It is important to note that there are various approaches to defining law, and they tend to be closely related to the research interests of the particular scholar proposing the definition. So the term law, we've got various definitions. So I actually picked a few definitions from some of the scholars. So there's no correct or incorrect definition of law, and each of the definition contributes to our understanding of law. Each of the theories tends to have a particular emphasis. The influential legal anthropologist E. Adamson Hobel remarked that to seek a definition of law is akin to searching for the Holy Grail. So the first scholar I used was Donald Blake, a leading law and society scholar, offers a definition of law that reflects the popular conception of law as law is governmental social control, the normative life of a state and its citizens. Blake views law as a social control by the government. Social control is defined as the regulation over the actions of individuals or groups. Lovemore Maduku also concurs with the definition stated above, and he stated here law as the rules and regulations that govern human conduct or other societal relations and are enforceable by the state. I'll then move on to the introduction. Law and society are identified with one. Society turns into the wilderness without the law. Law likewise should be changed by the progressions the general public countenances in light of the fact that without the vital changes, law cannot keep pace with the society. Without the control of the law, the general public turned into the wilderness or possibly primitive. So along these lines, to keep the general public tranquil, we have to make an amicable connection between law and society. So we can relate that for law to function, it needs a society. So and for laws to be effective and useful, there should be a society. Therefore, law and society are deeply embedded within each other. So my first sociologist is Rescue Pound. Rescue Pound put emphasis on the importance to distinguish between law in action and law in books. So it's been seen that law can be stated in books, but they cannot be practiced. They cannot be put into practice. Sometimes there are sort of many ways that they can be used to manipulate the law, maybe in the favor of those in the ruling power. But Rescue Pound's purpose, however, was not confined to identify the tension between the two, but he wanted to show how they can be harmonized. He sought to confirm that the latter conform to the former. As he put it, in conflict between law and books and the national will, let us not be legal monks. So for Pound, the task of lawyers and legislators is social engineering. He states that the law, by identifying and protecting certain interests, ensures social cohesion. By interest, he meant a demand or desire which human beings, either individual or through groups, seek to satisfy. The purpose for social engineering is to construct as efficient a society as possible, one which ensures the satisfaction of the maximum of interest with the minimum friction and waste of resources. Rescue elaborate the theory of interest to include individual interests, and those are the interests comprising of the physical, personal, free will, reputation. Then the public interests, which include peace, healthy, and so on. So, having categorized this, he proceeded to examine the various legal means by which they are secured. He argues that when interests conflict, they may be weighed and balanced only against the interests on the same plane. So, if there is a clash between personal interests, then they should be weighed against personal interests. This means that an individual interest must not be weighed against a public interest. This means that an individual interest must not be weighed against the public interest. In the event of new interests emerging, he suggested that they be tested by the reference to certain jural postulates for civilization, of civilization for recognition. So this is what Rescue Point is saying concerning law and society. But however, Rescue Point faces criticism from other sociologists, and Alan Hunt actually stated that he cannot be seen as having developed a sociological theory. So, due to the critics that have been raised, some of the sociologists concluded that he cannot be considered to have developed a sociological theory. One of the idea of balancing when a judge has to select between competing interests, it has been criticized that each has its own pattern, and the different types of interests that may be involved are many and different. So it is difficult to balance between the interests. And it should rest on the judge to translate the activity involved in the case before him in terms of an interest, and to select the ideal with reference to which the competing interests are measured. Rescue Point also assumes that it is a simple matter to know the real interests of people or individuals, but we are all manipulated to a greater or lesser extent, maybe by advertising or any other forms of persuasion. So it's very difficult to know the interests of people, because some may be manipulated by advertising, some may be persuaded. Therefore, the interests of the people are very difficult to depict. So moving on, I'll move on to Emil Durkheim. As one of the sociologists who have made an impact on concerning law and society. So he's generally concerned about what holds the law, what holds the society together. He had two essential claims, which are: he argues that a society develops from religion to secularism, from collectivism to individualism. Law becomes less penal and more restitutive in character. He claims that the function of punishment is an expression of collective sentiments by which social cohesion is maintained. The two claims are, I'll, I'll briefly unpack the two claims which Durkheim had mentioned. So the first claim that Durkheim has mentioned is law and solidarity. Society produces two distinct forms of social solidarity, that is, mechanical solidarity and organic solidarity. So the former is to be found in simple homogeneous societies which have a uniformity of values and lack any significant division of labor. The latter, on the other hand, is to be found in society which have developed a division of labor, hence exhibit a strong degree of interdependence. So instead of homogeneity, there is considerable differentiation. Then, so individualism replaces collectivism. Durkheim identifies also an important relationship between mechanical solidarity and repressive law, and between organic solidarity and restitutive law. So Law in the former is essentially penal, but with increasing differentiation, disputes tend to be resolved by recourse to restitutive law, which includes all civil law, that is procedural law, and major parts of the administrative law. So, through analysis of Daykem treats law and morality as virtually synonymous. He concludes that law is derived from and is an expression of social morality. I'll give an example of how law is derived from the society or is an expression of social morality. We'll take an example of the country Zimbabwe. In Zimbabwe, abortion is morally wrong, and up to now, it has not been recognized as something that is women's rights. It is only done under certain circumstances where there is necessity. And also, I'll take the issue of same-sex marriage. Also, the issue of the same-sex marriage in Zimbabwe, it is still treated as a crime. Zimbabwe has not yet allowed same-sex marriages, and generally it was morally wrong. So we can conclude that law is derived and is an expression of the society. So Raymond Wax concludes that in the absence of moral commitment to support it, law ceases being a part of a society. So the second claim is on the function of punishment. According to Daykem, a crime is closely related to social values expressed in the collective conscience, and according to him, an act is criminal when it offends the strong and divine states of the collective conscience. So, according to Daykem, crime is an inevitable of social life, and it is a factor in public health, an integral part of orally healthy societies, and the punishment as a crucial element in its notion of crime. So, by punishing those who offend against the state, it reinforces the collective conscience. So, punishment is defined as a passionate reaction of graduated intensity that society exercises through the medium of a body acting upon those of its members who have violated certain rules. So, for example, we have got in Zimbabwe, we've got in criminal cases where the criminal law and evidence act, which stipulates the type of crimes and the relevant punishment depending on the gravity of the crimes. So in his essays in the book called The True Laws of Penal Evolution, he propounds the following two laws. One, the intensity of punishment is greater the more closely societies approximate a less developed type, and more central powers assuming absolute character. Then secondly, the deprivations of liberty vary to the seriousness of the crime tend to become the normal means of social control. So he's saying that as the society progresses, the form of punishment becomes less violent and less harsh. For example, in the primitive societies, death penalty was worsened by the cruel acts like skinning alive, crucifixion, or boiling alive. So, for instance, in the case of Ezizes Makwanyane, the South African case of Ezizes Makwanyane, dealing with the constitutionality of death penalty. So the applicants in the Makwanyane case have been convicted of murder and sentenced to death. They challenged the constitutionality of the legislative provision, section 277, subsection 1, paragraph A of the Criminal Procedure Act, which made capital punishment a legally valid sentence. The main judgment found section 277, subsection 1, paragraph A, infringed upon the constitutionally recognized right not to be subjected to cruel, inhuman, and degrading treatment or punishment. This infringement was because capital punishment impacted to raise the right to life and dignity. So the court noted that capital punishment did not merely infringe upon the right to life and the right to dignity, but it completely extinguished those rights. So, as the right to life and dignity was seriously infringed, this in turn demonstrated the infringement of the primary right not to be subjected to cruel, inhuman, and degrading treatment or punishment. So the court also found, however, that there was no evidence that the death penalty has a stronger deterrent or preventative effect than life imprisonment. It also found that the retribution is not a reason compatible with the type of society to which the South African uh, constitutional aspires. So the case above illustrates how the society influences the application of the law and stated above. So the case above illustrates how the society influences the application of the law and society. It supports Dakin's theory as it stands, and in the case mentioned above, the death penalty is now seen as cruel, inhuman, and degrading, and hence it cannot be applied anymore. In Zimbabwe, there is no death penalty as a sentence. Hence, the society progress as the society progresses, the punishment becomes less harsh and becomes also lenient. In regards to all that has been said, Jakim also faced a lot of criticism. It has been argued by modern scientists that, contrary to Jakim's thesis, repressive law actually was actually less important in simple or primitive societies. His concept of the state has been attacked. He regards the state as an expression of the collectivity. It is treated merely as an instrumental organ, as a means by which offenders are punished. Also, his suggestion that crime is a factor in public health has been denied by several science writers in general, and finding it unconvincing on a number of grounds. So then move on to Max Weber. Max Weber's sociology of law may be considered under three heads. That is his topology of law, his theory of legitimate domination, and his analysis on the relationship between capitalism and law. And these will be briefly discussed, and I'll discuss these in brief. He mentions the substantive it mentions some of these which types of law, which it says the substantively irrational law, or where decisions are made ad hoc and based on ethical, emotional, or political considerations. Then substantively irrational law, this is exemplified by the certain theoretical legal systems, and in this system there is some attempt to construct a doctrinal system of principles and rules. Then in the formally rational law, it is a gapless law system which contains answers to all legal problems. Then the formally irrational law, decisions are made on the basis of tests beyond the control of human intellects. So Weber distinguished between formal and substantive systems. He states that the difference lies in the extent to which the system is self-sufficient. That is, the rules and the procedure required for decision making are available within the system. Secondly, it is between rational and irrational. These terms describe the manner in which the materials, that means the rules or the procedures which are taken, are applied in the system. Thus, the highest stage of rationality is reached where there is an integration of all analytical derived legal propositions in such a way that they constitute a logically clear and internally consistent, and at least in the theory, a gapless system as main. So, for Weber in general, the formal rationalization of law in the Western societies is a result of capitalism. Interest is a strictly formal law and legal procedure, and the rationalism officialdom in absolutist states, which led to the interest in the codified systems, are inhomogeneous law. Then I'll move on to the second theory of legitimate domination. Weber attempts to explain why people believe they are obliged to obey the law, and leads him to draw his whole distinction between three types of legitimate domination. That is, so these are the traditional, the charismatic, and the legal rational domination. So it is, of course, the third type that is central to feature of for Weber's account of law. And though the concept of legal rational authority is bound up with this theory of value, which argues for the sociologist of law adopting a detached view of this subject. The important correlation is between the form of domination and the modern bureaucratic state. Under the other forms of domination, authority resides in persons, and under bureaucracy, it is vested in rulers. Legal rational authority is characterized by impartiality. This is where officials exercise their responsibility without hatred or passion, hence without affection or enthusiasm. The domination norms are concept of straightforward duty without the regard to personal considerations. Of importance, Weber argues that while the legitimacy of the first two types depends on the specific relationship between ruler and subject, the source of legitimacy of legal rational domination is impersonal. Obedience is therefore owed to the legal order. Therefore, in other words, legal domination is not dependent upon the extent to which the law reflects the values, but to which people who accept its legitimacy subscribe. So I'll move on to capitalism and law. Weber is of the view that economic forces do not affect the law. He claims that generally it appears so Weber is of the view that economic factors does not affect the law. He claims that generally it appears that the development of the legal structure has no means been predominantly determined by economic factors. He used an example of England to prove his thesis that only where the law is systematized so as to ensure the predictability of economic relations can capitalism develop. By his own admission, however, the emergence of capitalism in England occurred without a formally rational legal system. Weber shows how in many respects the English common law was, during the development of the capitalist economy, highly irrational. A second feature of the English legal system to which Weber ascribes considerable significance in the advancement of capitalism is the legal profession. He shows how lawyers in England traditionally served as advisors to businessmen and corporations. This enabled and encouraged them to modify the law to suit the interests of their common clients. So therefore, what Weber is really saying is that England developed a capitalist economic system despite the absence of legal systematization, because other important components of the legal systems engendered it, but that it may have developed even more rapidly and more efficiently if the common law had been less irrational and unsystematic. All these have been said. Weber also faces criticisms and of the relation between law and bureaucratic state is distorted by his concern with legitimacy. This accords unwarranted primacy to this aspect of the political structure. Another problem was portrayed in his discussion on the relationship between law and economic order. Weber adopts an excessive empiricist view. So I'll then move on to the Marxist theory by Karl Marx. So Karl Marx says that lawyers' one main purpose are to protect and promote the interests of the ruling class. The Marxist theory is built on the principles of dialectical materialism that view all things and phenomena in nature as interconnected and conditioned by each other. So the basis of these theses is that material conditions of the society determine everything else in the human institutions. So Marx argues that each period of economic development has a corresponding class system, and classes are determined by production, and therefore an individual's class is determined on is dependent on his relation to the means of production. Marx distinguishes between the economic structure of society, which he called the base, and the superstructure, which was determined by the base. So, as the economic, no, 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 no. So law is a component of the superstructure and is controlled by the base. So as the ruling class owns the means of production and it controls the base and uses the law to protect its interests. It is not the conscience of men that determines their being, but on the contrary, their social being that determines their consciousness. So to Karl Marx, law is a vehicle of oppression. Oh my God. So, according to Karl Marx, law is a vehicle of oppression, and under capitalism, the ruling class suppresses and exploits the working class. And the ruling class also suppresses other classes in order to remain in control of the economic means of production. So, the Marxist theory has been illustrated through the case of Kiga versus Minister of Justice. The case challenged the extension of office of the Chief Justice Luke Malala for an additional period of 5 years beyond the mandated constitutionally required retirement age of 70. So the human rights lawyer Musa Kika, under the 2013 constitution, judges of all the superior courts have to retire at the age of 70. So in terms of the new constitutional amendment, section 186 through the Constitution of Zimbabwe Amendment number 2, 2021, President Emmerson Mnangagwa would allow him to stay for a further 5 years. During the December 2019, it became clear that the cabinet approved a constitutional amendment that would prolong the tenure of all the judges, of all the Superior Court judges. And according to Kiga, this was a move that was stigmatized as a form of authoritarian consolidation. According to Kiga, the purpose of the amendment was to assail judicial independence. Hence, this case shows how the ruling class can manipulate the law to satisfy their needs or their desires. Hence, this case shows how the ruling class can manipulate and use the law in their favor to satisfy their needs, be it economic or social or political needs. So this law is a vehicle of oppression according to Karl Marx. The ruling class oppresses other classes in order to remain in control and in control of the economic means of production. The Marxist theory also includes the legal fetishism, which is the condition in Babler's ways where individuals affirm that they owe their existence to the law rather than the reverse. In thus, they regard there's two forms of fetishism, which are commodity fetishism and legal fetishism. So the two are inseparably related, to which humans are first reduced to abstractions and then dominated by their own creations. Marxists also reject the concept of consensus model of a society. So it perceives society as essentially unitary. The legislature represents the common will, the executive acts in the common interest, and the law is a neutral referee that is administered without fear or favor for the common good. There are no fundamental conflicts of values or interests. On the other hand of the spectrum is the conflict model, which conceives of society as divided into two opposing camps, those who have property and power and those who do not have. Then conflict lies at the heart of the society, so that individuals or smaller groups have their position defined by the very structure of the society. They exist as components of one or other of the two sides. Law is, in this image, far from being a neutral referee, is actually the means by which the dominant group maintains its domination. However, the theory exaggerates the extent to which law is an instrument of ruling class interests. While law is in many respects an instrument of class rule, it is also in other respects a phenomenon that has life outside the realm of class struggle. So So the last segment that I'm going to touch on is on the functions of papers of law. The main functions of law is to promote justice. Law must serve the ends of justice, and this function is accepted by all legal systems. The papers is regarded by Harlow and Khan as the foremost papers of law. They they express it as follows. The first and foremost purpose of laws is to maintain peace or in the community. Man must live in a society if he is to achieve useful development. Society, however, cannot exist without law. For without rules of conduct, there could be Society, however, cannot exist without law, for without rules of conduct there cannot be order, and without order there cannot be peace and progress. So in a nutshell, law is a critical for a general public, for it fills as a standard of direct for residents. It was additionally made to accommodate legitimate rules and requests upon the conduct of all natives, and to continue the value on the three parts of administration. The law is vital in light of the fact that it keeps the general public running. Without law, there would be turmoil, and it would be survival of the fittest, and every man for himself. Thank you so much for watching this video. Bye.